Article 1 of the Indian Constitution declares India to be a union of states. It specifies that India shall be a union of states, rather than a federation of states, which means that India is not a loose association of independent states but a single entity comprising various states and territories. It also lists out the territories that comprise India, which include the states, union territories, and any territory that may be acquired in the future. The current list of states and union territories in India is provided in the first schedule of the Constitution. Overall, Article 1 lays the foundation for India's political structure and defines the territorial boundaries of the country. Article 2 of the Indian Constitution confers the power to admit or establish new states to the Parliament of India. The article states that the Parliament may, by law, admit into the Union of India or establish new states on such terms and conditions as it deems fit. The article allows for the formation of a new state by separating territory from an existing state or by merging two or more states or parts thereof. However, before taking such a decision, the Parliament must ensure that a resolution in support of the proposed creation or merger of a state has been passed by the Legislative Assembly of the concerned state or states. Moreover, the Parliament must also ensure that the proposed state's boundaries are defined in a fair and reasonable manner, taking into account the interests of all affected parties. The article provides for the appointment of a boundary commission to determine the boundaries of a new state, which is to be constituted by the President of India. The article also empowers the Parliament to alter the names, boundaries, or territories of any existing state or states, again subject to the approval of the Parliament. However, such a decision should not be made without consulting the state or states concerned. In summary, Article 2 of the Indian Constitution grants the Parliament the power to admit or establish new states and alter the boundaries, names, or territories of existing states, subject to certain conditions and procedures, to ensure a fair and just representation of all the affected parties. Article 3 of the Indian Constitution provides for the power of the Indian Parliament to create new states or alter the boundaries of existing states. According to this article, Parliament may by law 1. Form a new state by separating territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. 2. Increase the area of any state or diminish the area of any state. 3. Alter the boundaries of any state. However, before passing such a law, the President must refer the bill to the concerned state legislature for its views within a reasonable time. If the state legislature passes a resolution against the bill, Parliament may still proceed with the law, but only after considering the objections and making appropriate modifications. The aim of this article is to provide for the reorganization of states, which can be useful for administrative, linguistic, or cultural reasons. However, the power to reorganize states is not absolute, and must be exercised with due regard to the principles of federalism and the interests of the affected states and people. Article 4 of the Indian Constitution deals with the power of the Indian Parliament to make laws for the creation or abolition of states. It states that the Parliament may by law 1. Form a new state by separating the territory of an existing state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. 2. Increase the area of any state. 3. Diminish the area of any state. 4. Alter the boundaries of any state. The Parliament can exercise these powers only after consulting the concerned state legislature. In other words, the Parliament cannot pass any law affecting the boundaries of a state without the consent of the state legislature concerned. This article is important because it provides for the reorganization of states in India to ensure better governance and administration. It has been used several times in the past to create new states, such as Telangana, Uttarakhand, and Jharkhand, and to modify the boundaries of existing states, such as the creation of the Union Territory of Dadra and Nagar Haveli and the merger of the Union Territories of Daman and Diu. Article 5 of the Indian Constitution deals with the citizenship of India. It states that at the commencement of this constitution, every person who has his domicile in the territory of India and 1. Was born in the territory of India, or 2. Either of whose parents was born in the territory of India, or 3. Has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. This article provides the criteria for determining the citizenship of India at the time when the Constitution came into force. It establishes that anyone who was born in India or whose parents were born in India or has been residing in India for at least 5 years at the time of the Constitution's commencement is considered a citizen of India. It is important to note that citizenship laws in India have undergone significant changes since the Constitution was enacted. In 1986, the Indian Citizenship Act was passed, which provides for the acquisition and termination of citizenship by various means, including birth, descent, registration, naturalization, and renunciation. Article 6 of the Indian Constitution deals with the rights of citizenship for migrants to India from Pakistan. The article lays down the conditions for granting citizenship to those who migrated from Pakistan to India after the partition of the country in 1947. According to Article 6, a person who migrated to India from the territory of Pakistan after March 1, 1947, but before July 19, 1948, and has been residing in India since then, shall be deemed to be a citizen of India. This provision was included in the Constitution to address the issue of large-scale migration that occurred during the partition of India. The provision for granting citizenship to migrants from Pakistan is based on the principle of jus soli, which means that citizenship is determined by the place of birth. However, in this case, the provision also takes into account the time of migration and the period of residence in India. It is important to note that Article 6 only applies to migrants from Pakistan and not from other countries. Additionally, the Citizenship Act of 1955, which was enacted after the Constitution, provides for additional provisions for the acquisition and termination of citizenship. In summary, Article 6 of the Indian Constitution grants citizenship rights to those who migrated from Pakistan to India during a specific period and have been residing in India since then. The provision was included to address the issue of large-scale migration during the partition of India in 1947. Article 7 of the Indian Constitution provides for the citizenship of certain persons who migrated to India from Pakistan after the partition of India in 1947. This article lays down the criteria that such persons must meet to be deemed citizens of India. According to this article, if a person migrated to India from Pakistan between the 19th of July 1948 and the 1st of March 1949, then he or she will be deemed to be a citizen of India if 1. The person, or either of his or her parents or any of his or her grandparents, was born in India as defined in the Government of India Act, 1935, as originally enacted. 2. The person has been ordinarily resident in India since the date of his or her migration. In simpler terms, this means that if a person or his or her parents or grandparents were born in India as defined in the Government of India Act, 1935 and he or she migrated from Pakistan to India between the 19th of July 1948 and the 1st of March 1949 and has been residing in India since then, he or she will be considered a citizen of India. It is important to note that this provision applies only to persons who migrated from Pakistan to India during the specified period and not to persons who have migrated to India from any other country. Additionally, the provision only applies to those persons who meet the eligibility criteria mentioned above. Article 8 of the Indian Constitution deals with the citizenship rights of people who migrated to India from Pakistan before the establishment of the Indian Constitution. It provides that any person who migrated to India from Pakistan on or after March 1, 1947, but before July 19, 1948, and has been residing in India since then, will be deemed a citizen of India. This article applies to people who migrated from what is now Pakistan to India during the partition of the country in 1947. The purpose of this article was to provide citizenship rights to those people who were displaced due to the partition and had made India their permanent home. However, this provision does not apply to persons who were or are declared to be enemies or have been associated with enemies during any war between India and Pakistan. In other words, if a person was involved in any activities against India or was declared an enemy of India, they would not be eligible for citizenship under Article 8. It is important to note that Article 8 was added to the Indian Constitution by the Constitution Amendment Order 1950. This amendment was made to give effect to the Delhi Agreement 1950, which was signed between the governments of India and Pakistan to provide for the protection of minorities in their respective countries. Article 9 of the Indian Constitution is a short and simple provision that relates to the rights of citizenship. It states, persons voluntarily acquiring citizenship of a foreign state are no longer citizens of India. In other words, if an Indian citizen voluntarily acquires citizenship of another country, they automatically lose their Indian citizenship. This provision is in line with the principle of single citizenship, which is enshrined in the Indian Constitution. The principle of single citizenship means that a person can only have one citizenship at a time. Unlike some countries that have dual citizenship or allow their citizens to hold multiple passports, India only recognizes one citizenship per individual. Article 9 is significant because it helps to maintain the unity and integrity of India. It ensures that Indian citizens are fully committed to the country and do not have divided loyalties. It also prevents foreign countries from interfering in Indian politics by influencing the decisions of Indian citizens who hold dual citizenship. It's worth noting that there are some exceptions to Article 9. For example, a person who is a citizen of India by birth or descent may be allowed to acquire the citizenship of another country without losing their Indian citizenship. Similarly, a person who is already a citizen of another country may be eligible for Indian citizenship through naturalization, but they would have to renounce their previous citizenship. In summary, Article 9 of the Indian Constitution is a crucial provision that helps to define the rights and responsibilities of citizenship in India. It ensures that Indian citizens are fully committed to the country and prevents foreign interference in Indian politics. Article 10 of the Indian Constitution provides certain rights to every person who is arrested or detained by the authorities. These rights are aimed at ensuring that a person is not subjected to arbitrary arrest or detention, and that the person is treated fairly and given a speedy trial. The article states that a person who is arrested must be informed of the grounds for their arrest, and must be given the right to consult and be defended by a legal practitioner of their choice. This ensures that the person has access to legal representation and is able to defend themselves effectively. In addition, Article 10 stipulates that a person who is arrested must be brought before the nearest magistrate within 24 hours of their arrest, excluding the time necessary for the journey from the place of arrest to the court. This ensures that a person is not detained for an extended period without being produced before a court. Furthermore, Article 10 guarantees that every person has the right to be tried in a court of law by a competent and impartial tribunal. This ensures that a person is not subjected to arbitrary detention or punishment without due process of law. Overall, Article 10 of the Indian Constitution provides important safeguards for the protection of the rights of persons who are arrested or detained, and ensures that the justice system operates fairly and efficiently.